5 seconds to go. Start. The High Court relied upon another judgment of this court in the case of State Bank of India versus D.C. Agarwal. In that matter also, the High Court had quashed the punishment imposed on the respondent since the CVC report had not been furnished to him. In paragraph 5 of the judgment, this court observed as may be that the disciplinary authority has recorded its own findings, and it may be coincidental that reasoning and basis of returning the finding of guilt are same as in the CVC report, but it being a material obtained behind back of the respondent without his knowledge or supplying of any copy to him, the High Court, in our opinion, did not commit any error in quashing the order. Therefore, in the present case, the High Court set aside the punishment imposed on the respondent. It also issued a mandamus to the appellant bank to consider the respondent for promotion which he had sought. Being aggrieved by that judgment and order, this appeal has been filed. Mr. Bhatt, learned senior counsel, appeared for the appellants, and Mr. Gupta, learned senior counsel, appeared for the respondent. It was submitted on behalf of the appellants that the High Court had erred in interfering with the punishment and in any case directing consideration of the respondent for promotion. Mr. Bhatt, learned senior counsel for the appellant, submitted that the bank was required to refer the matter to the CVC, which is constituted under the Central Vigilance Commission Act 2003. Regulation 19 of 1982 regulations framed thereunder makes it obligatory whenever there is a vigilance angle involved. This regulation reads, consultation with the Central Vigilance Commission. The bank shall consult the Central Vigilance Commission wherever necessary in respect of all disciplinary cases having a vigilance angle. That apart, he submitted that the bank had arrived at its decision on its own and not because of any dictate by the CVC. Charge number 1 was a serious charge. It was already proved in the departmental inquiry, and although it is true that at some stage the bank management thought that a lenient view may be taken, it specifically arrived at its own decision, as can be seen from the appellate order. In his submission, there was no prejudice caused to the respondent by not making the report of the CVC available to him. Conduct of this type required a stringent action to be taken. He relied upon the judgment of this court in the case of Regional Manager versus Nikunja Bihari Patnaik, reported in this court, has held in that matter that when the bank officer acts beyond his authority, it is a misconduct and a proof of any loss to the bank is not necessary. That was a case where also a senior officer of the Central Bank of India had allowed overdrafts and passed checks involving substantial amounts beyond his authority and the respondent had been dismissed from his service. Mr. Bhatt submitted that in the instant case, the appellant bank had in fact been lenient in imposing the punishment of merely reducing the respondent by 2 grades. It was then submitted by Mr. Bhatt that in any case, the direction to consider the respondent for the promotion could not be sustained. He pointed out to us that the respondent had been punished earlier for similar conduct. He was considered for promotion in the year 2002 and subsequent to the impugned judgment in the year 2005 also, but was not found fit. The learned counsel for the appellant bank submitted that the question of promotion to such a senior post had to be decided on merits and suitability of the candidate. Mr. Bhatt further submitted that even if the punishment was to be interfered with, there was no case for direction for promotion. It was submitted on behalf of the respondent, on the other hand, that there was no loss suffered by the bank and at the highest it was a technical lapse. The bank management had also decided that a minor punishment was required, and it was only because of the dictate of the CVC that the disputed punishment had been imposed. Firstly, there was no reason to refer the issue to the CVC since there was no vigilance angle involved therein. That apart, the report of CVC was not made available to the respondent and it clearly amounted to denial of fair opportunity to defend. Mr. Gupta submitted that the denial of promotion was essentially because of this punishment or else the respondent would have been promoted. He therefore submitted that there was no occasion to interfere with the impugned judgment and order. Mr. Gupta submitted that the two judgments relied upon by the High Court in the case of Narayan Swamy and State Bank of India squarely applied to the present case and there was no occasion for this court. Stop.